Good afternoon for those of you on the East Coast, and good morning for those of you on the West Coast. My name is Felix Shipkovich, and I'm humbled for you to join um, our firm's webinar that will discuss enacted and proposed debt settlement legislation. We'll cover 2019 until present time, both proposed and enacted legislation. I'm joined by my colleague and co-host Bianca Petko. Um, if you're a returning guest from a recent CFPB convening webinar that we held a couple of weeks ago, welcome back. If you're new, we hope the next 45 minutes or so will provide you with an opportunity to learn and be acquainted with the recent legislative changes. Now, as Bianca and I were preparing with a wealth of information that we're going to deliver to you, we like to do our best job to keep you engaged, keep you interested, and even potentially provide you with a few jokes or facetious statements. I think that when it comes to discussing any regulatory or legislative changes, you do have to bring a little humor to the conversation. We will not be taking questions at the end of this webinar, but of course, our contact information is available both on our website, shipkovich.com, and also will be available to you on the last slide. For those of you who've joined to also learn about the recently proposed legislative change in the state of California, I left the best for last. And so if you can stick around with us, we will get to hear quite a lot of information about the recently proposed legislation affecting the debt settlement industry by Councilwoman Buffy Wicks. We'll digest that proposed legislation in detail and also provide you our thoughts. And that's one of the things that makes us a little different, is that we try to educate the industry, the debt relief space, with some information, humor, and in-depth analysis. So with that in mind, let's talk about what is the scope and purpose of today's event, or today's webinar. We'll talk about the enacted legislation in Virginia and Texas, and then we'll move on to the proposed legislation in Illinois, New Jersey, New York, and of course, for those of you who are eager to learn more about the proposed legislation in California, as I said, we'll leave it to the very end. Now, I'm going to turn it over to my colleague, Bianca Petko, and she will talk to you about the enacted legislation.
Hi, everyone. All right, so we're going to start with Virginia. So by now, hopefully you've had a chance to see our update on HB 1553, the newly enacted Virginia law, which amended and reenacted the Code of Virginia to include a chapter on debt settlement service providers. If you did not get a chance to read our update yet, I've included on this slide a very brief summary, but we recommend you read the update on Debt Relief Watch for more specific information. So as you can see here, the bill was enacted around 3 weeks ago on April 7th and goes into effect on July 1st of next year, 2021. The bill itself defines debt settlement service companies as any action or negotiation initiated or taken on behalf of any consumer with any creditor of the consumer for the purpose of obtaining debt forgiveness of all or a portion of the credit extended by the creditor to the consumer, or a reduction of payments, charges, or fees payable by the consumer. It's a lot of legal language, but it's probably something you've seen before. So to simplify it a bit, basically now it includes a license requirement in Virginia and fee caps, which are now no more than 20% of the principal amount of the debt enrolled by a consumer into the licensee's service, or no more than 30% of the difference between the amount owed by a consumer at the time the licensee settles the debt and the amount to be paid by the consumer to satisfy the debt. All right, so next slide. So next we have Texas, which Texas is very straightforward and simple, and there's really not too much to dive into here. There are some minimal increases in fee costs, which I've outlined and highlighted in bold here for you. But basically these new fee amounts go into effect on July 1st of this year. And you can see the numbers, it's really minimal increases. It's nothing too crazy. But now onto the various proposed laws from the last year, a few of which have been creating quite a bit of buzz within the industry. So Felix will take it over from here.
Thanks, Bianca. So let's begin with Illinois. Illinois is the easiest one to cover. It'll literally take about 30 seconds. Look, what you really have to know is that it was introduced in January of 2020. It's currently assigned to the Financial Institutions Committee, where it's pending. There's not a lot of movement. Uh, there's nothing to be really alarmed about unless you're really alarmed about providing your email address of record to the Department of Financial and Professional Regulation. That really is all there is. I don't want anybody to be too concerned about the state of Illinois, particularly this piece of legislation, but certainly at the point that it's enacted, and we'll keep our readers, our followers informed of when it gets enacted, you'll have to just make sure that your email is provided as an email of record. Let's move on. Let's move on to the great state of New Jersey, the Garden State. For those of you who attended our firm's full day regulatory workshop 6 months ago in Irvine, California, we covered the state of New Jersey proposed legislation from 2019. And it's moving at a very, very slow pace. Now, let's talk about the state of New Jersey. For those of you who are practicing in the debt relief space and particularly have focus in the debt settlement space, the best way to discuss the kind of the scope of the space is that you got three buckets. I call them the three buckets because it's just easier to remember that way. The first bucket are the states where you do not need to be licensed. The second bucket is the state where you need to be licensed and you have to be aware of the fee caps. And the third list of states, and it's a very small list of states, particularly in this case, the state of New Jersey belongs to that list, along with, for instance, like Louisiana and Hawaii, where what the industry considers to be attorney-only state or not-for-profit state, meaning that under New Jersey's current debt adjuster law, which is administered and enforced by the Department of Banking in the state of New Jersey, only non-for-profit social service agencies and non-for-profit consumer credit counseling agencies may operate debt adjustment services in the state. Okay, the same doesn't also attorneys, as I mentioned, are exempted in the state of New Jersey. What this proposed legislation that's been moving at a snail's pace, very, very slow, is trying to do something different. It says, look, let's open up, let's change the definition of the debt adjuster law, and to allow for for-profit adjustment companies to conduct business in the state as long as the company, one, doesn't receive or hold actually or constructively consumer funds, which is very important, right? Because for those of you who are in the debt settlement space, you don't hold customer funds. You shouldn't hold it. You should be aware of the TSR amendment and clearly the everything surrounding the Federal Trade Commission rules, particularly the telemarketing rule, which is the second prong. The bill wants to allow for-profit debt settlement companies to operate in the state and to operate under a license. For those of you who are eager to see what happens in the state of New Jersey, we'll keep our eyes and ears open. But as of right now, it's still currently pending in the Senate Commerce Committee. And as we pointed out in bold at the very bottom of the slide, it's moving very, very slowly through the state legislature. Now, we're not leaving New Jersey yet. I'm sorry to disappoint you, but we want to stick around in New Jersey because something happened earlier this year, just about 2 months ago, which was a surprise to some debt settlement companies, or for us legal debt settlement geeks. We had a resolution. We had a resolution that was issued by two Democrats who are state legislators. You have their names right at the top of this slide. And first of all, what is a resolution, right? A resolution is not legislation. It's not voted on technically. It doesn't become law. At the bottom of the slide, just in case if you really wanted to know more how a resolution in the state of New Jersey is defined, it's just something that's adopted by state and general assembly to express the policy or opinions of the legislature. It's often used to petition Congress to take certain actions, establish study commissions composed entirely of legislators or appointees of the presiding officer, and so on. Look, it is what it is, right? It's just nothing short of a resolution by, adopted by, proposed and adopted by New Jersey state legislature without it actually being the law. It's more of a policy effort, right? So what was the scope of this resolution from 2 months ago? It urges efforts at state and federal levels to protect minority communities from certain practices of debt settlement companies. Now, why don't we stop right here? I think we need to digest this a little bit more. Because if the resolution is trying to urge federal and state level protection for minority communities, the question comes down to was there a study, was there an increased number of complaints within the state of New Jersey, particularly affecting certain minority communities where debt settlement became an issue? Bianca and I have done a pretty comprehensive review of the sort of, we call it the history of this resolution. We couldn't find anything by these two legislators who said anything publicly that minorities in the state of New Jersey were affected. And then the question is, what exactly is considered to be certain practices of debt settlement companies? That seems to be a very, very broad statement. And you could, I guess, make a judgment for yourself for what that really means. But again, there's nothing historically that leads us to believe that in a very recent future there were certain practices in the debt settlement industry or companies in the state of New Jersey. And please bear in mind, New Jersey is an attorney or not-for-profit state only, so not really sure where the first prong comes into effect. The second is considering legislation restricting debt settlements companies on safe and unsustainable loans directly or indirectly to consumers. Okay, well, we could stop right there. Because for-profit companies don't operate in the state of New Jersey, I'm not really clear. I'm curious if you are listening to this webinar, how exactly do loans come into the play? There is an industry specifically geared towards loans for debt settlement companies for those who qualify, but this is not the same thing here. Really, again, going back to, well, who are these, why loans are at issue, and what really prompted the discussions about loans to consumers in the state of New Jersey to be at issue for these two legislators. Here's another one: encouraging the federal government to conduct a comprehensive review of its oversight of debt servicing companies, to include a review of federal bankruptcy laws. Before we move on to the next part of that prong, I'm not really sure. Also, comprehensive review of oversight of debt servicing companies to include review of federal bankruptcy rules. Federal bankruptcy rules and debt settlement companies are two different beasts. They're two different buckets, and it's very difficult to really discuss one with the other. One is federal law. One is a matter of federal privilege, not a right, which is consumer bankruptcy, 713 for that matter. And another one is essentially a debt settlement service. I'm having difficulty understanding why that was specifically put in here and what kind of review they're looking to conduct. Second prong: how debt settlement companies act as credit counseling services. Well, first of all, debt settlement companies, in my opinion, and I've worked with dozens of debt settlement companies over the years, do not provide credit counseling services. In fact, to the contrary, credit counseling is a separate beast. It's a separate type of business, regulated on a state level, and also regulated if you offer them for specific purposes. You need to get also approval from the U.S. Trustee's office. Not really sure how exactly one operates as the other. And then the third prong here is the status of these companies as money service businesses. Also, quite a lot of confusion, because money service businesses, money transmitters, are financial services companies. I am not really clear how debt settlement companies who do not receive clients' funds, and those funds go into third-party escrow accounts, operating in any way, shape, or form as money services businesses. So that also seems a little confusing. And a review of the enforcement of current laws and regulations by the CFPB and the FTC. Well, I think that probably is the most realistic and practical point here. So why did we decide to include this specific resolution as part of our presentation? Is because it sort of goes hand in hand with the lack of information that some legislators and other members of the debt relief space have in the debt settlement companies. And unfortunately, for whatever reason, I don't think they have a full information to understand the services. And hopefully, as we digested this resolution, you understand that without really having substantiated reason to issue these resolutions, I'm having difficult time understanding really the purpose and who exactly it's trying to protect. Now, I'm going to turn it over to Bianca again, and she'll talk to you about the proposed legislation in New York.
Thank you. Okay, so New York. New York is a bit denser, and we've included a lot of information on these slides for your own convenience to look at after the webinar when we post the slides, but for timeliness purposes, I'm only going to go over the most important bits. So most importantly to note, this proposed bill was first introduced last January in 2019, so it has been over a year since the bill was first introduced. So as you can see, it's moving very slowly through the New York State Legislature. As of January 8th of this year, it was referred to the Customer Affairs and Protections Committee, and it has been stalled there. And with coronavirus impacting a lot of state governments' ability to hold hearings, it will seemingly be stuck there for a while longer. Okay, so please note here with the definition of debt settlement companies that it is a two-pronged definition, which includes both any person engaging in or holding himself, herself, or itself out as engaging in the business of providing debt settlement services in exchange for or in expectation of any compensation or gain, or B, soliciting for or acting on behalf of any person engaging in or holding himself, herself, or itself out as engaging in the business of providing debt settlement services in exchange for or expectation of any compensation or gain. So this definition, just keep in mind in the back of your head, it'll come back up again during Felix's discussion of California's new proposed law to kind of compare and contrast the two states' definition. And there have been some exceptions to the definition in New York, including the attorney exception that we've seen in other states. So I've included that in here too. So most states that have licensing requirements have this attorney exception as well. So on the next slide, we have the debt settlement services and what they're defined as in the proposed law. So please note here the use of the phrase offering to act or acting as an intermediary between or on behalf of a debtor and one or more of the debtor's creditors, which again, Felix will compare and contrast to the newly proposed legislation in California, which uses the term prorater that you might have heard of or seen. So all in all, this New York proposed legislation wants to adopt, oh, you can go to the next slide, sorry. Wants to adopt the Uniform Debt Management Services Act, which is the UDMSA for short, very easy to say, which therefore means that it would be a licensing requirement and fees in accordance with those outlined in the UDMSA for New York now. So as you can see, the fee requirements on the next page, on the next slide, are quite dense, so don't be alarmed by them. But but we've taken the liberty to bold the most important parts within the fee section again for your convenience. So after the webinar, if you decide to review what we've discussed or you want to discuss it more in depth, you can look at those bold sections to kind of get a better understanding of it. But just note that they are taken directly from the UDMSA, which you might have seen before in other states. And that's roughly what is proposed in New York, but it is moving very slowly. So it might be on the back burner for a while in New York.
Thanks, Bianca. Also, this is obviously a lot of information, and the slides are quite dense. We realize that you may want to get a copy of this presentation. First of all, we'll make a copy of this presentation available on our firm's website, so you can go back and refer to it. Obviously, our presentation does not provide any legal advice, but it is there for information purposes. However, it's a good reference in case you have any questions. And we're obviously, both Bianca and I, available to answer any questions that you may have offline. Anyway, let's move on to our favorite state, the state of California. And this is where we're going to spend the bulk of our remaining session here, remaining part of the webinar. So for those of you who have been in the debt relief space, you probably have been aware through multiple channels about the recently proposed legislation in the state of California. So let's discuss it. There were actually two legislations that were recently proposed. In fact, what's interesting, both Assembly Bill 2443, which we'll discuss right now, and then Bill 2524, proposed on the same date, February 19th. For specifically Bill 2443, this was co-sponsored by Assemblywoman Buffy Dix and Assemblywoman Shirley Weber. What's interesting is that the one bill that has many in the debt settlement industry to be quite concerned about, and we'll discuss we'll discuss, in a few minutes, Shelley Weber did not co-sponsor. It was just co-sponsored by Buffy Diggs. Anyway, going back to 2443, co-sponsored by two Democrats. It's an active bill. It's in the committee process, in the Committee of Banking and Finance. And currently, as we are dealing with a global pandemic and both federal and state governments are operating at limited capacity, all hearings are currently postponed until further notice. What does that mean for you? It means you have an opportunity, if you disagree with this or the next to be discussed legislation, to voice your opinion and to discuss this with, your attorneys, your compliance staff, and obviously your representatives, even your local representatives. Even if you're out of state, ultimately it affects your business and affects your jobs. So, let's talk about the these two individuals. Both have been elected on a very progressive platform. They consider themselves progressives. Very well, I have to tell you that at least Buffy Wicks in her district, and we'll discuss it in a minute, she is in part of Berkeley and Oakland, California, which are known to have very progressive agenda. However, both women have ran on platform focusing on women's rights, civil rights, social justice, and education, which is the core foundation of progressive movement, right? Now, why are we talking about their background, right? Well, I think we should care, right? Because I think it's important to know that any proposed legislation that gets proposed and then subsequently enacted needs to be carefully understood, and understand that legislation is part of a process that I think you need to know your audience, right? You need to know exactly what caused somebody to propose this legislation, right? Somebody didn't just wake up in the middle of the night and said, "Hey, I'm going to propose legislation that's going to, change the Consumer Legal Remedies Act in the state of California." Obviously, there must be a reason behind it. So what does this co-sponsored bill get to do? And the bill basically would specify vicarious liability under the provision that would be imputed to persons or entities providing payment processing services for any company that negotiates or promises to negotiate the settlement of debts owed to another. And at the bottom, you see in italicized font a little bit more information. Well, the actual literally. What that revised language of the Consumer Legal Remedies Act looks like. Now, that's this vicarious liability. For those of you who are not attorneys, I'll make it very simple. Vicarious liability means you're going to be liable for the acts of a third party, right? So in this case, the vicarious liability extends to payment processing services. And if you heard me speaking a few minutes before, payment processing services could be one of the following. They could be one, money transmitter, or two, technology company. If you look at the definition of a payment processor from the FinCEN perspective, FinCEN is a federal regulator, payment processors are deemed to be technology companies, and generally they do not need to be registered as money transmitters. You have to be able to fall within the four corners of a definition of a payment processor. Some states also, in fact, exclude payment processors from being a money transmitter. So the question that's begged to be asked here is questions. What we need to ask is, why are we including payment processors? Have payment processors been an issue? Have technology companies in the space been an issue? Two, what kind of payment processors? Are we talking about money transmitters, or are we talking about technology companies? Three, let's take, for example, a company like, I don't know, randomly select a household name like PayPal, right? I'm using PayPal solely for this example, not for any other reason. So we basically saying that if PayPal is working with a debt settlement company, and that debt settlement company commits some unlawful or deceptive act, then we would hold PayPal to be responsible, vicariously responsible for any type of wrongdoing. That seems a little silly to me. Obviously, if PayPal knows, has full knowledge that they're getting into bed with a company that's committing fraud, sure, I can understand that you can't just willfully close your eyes on any type of illegal activities. But to really force payments processors, and as I said, I'm kind of scratching my head here. I'm thinking, who are exactly these payment processor companies? to be vicariously liable for the acts of debt settlement companies seems a little bit far stretched. And I really don't know if how and why um, both of these legislators decided to include this vicarious liability. Um, so just so you understand, I'm asking these hypothetical questions and asking all these questions, in fact, for this piece of legislation is because Bianca and I have spent countless hours in the past few weeks of really, um, you know, combing through secondary materials available to attorneys on Westlaw. We come through social media profiles for these both of these legislators. We watched countless videos, interviews. We couldn't find, after probably dozens of hours, anything why, in fact, payment processors were an issue. Anyway, if you're a payment processor, be aware that Assembly Bill 2443 is going to affect you. So please beware. Now, let's move on to the 800-pound gorilla. Oh boy, Bill 2524. And that one got a lot of people quite worried. It was proposed on, as I mentioned a few minutes ago, also on February 19th, 2020. It is an active bill, and it's currently in the process of making its way through the Committee of Banking and Finance in the state of California. On the next slide, I'll actually provide you with who the names of the individuals who sit on that committee, but it's still there and it's pretty active. We included, for the purposes of this webinar, something that you can do now if you feel that this bill concerns you. Remind you, we're not a lobbying firm, we're a law firm, and we're here to advise you and counsel the industry on issues that are pertinent to them. And as we're going to discuss this bill, we're going to really dissect it and point out some of the inaccuracies. In fact, it'll point out a lot of the issues with the legislative drafting, really terrible legislative drafting, as I'll point it out, I'll show to you in a couple of minutes. There's nothing that stops you from submitting a letter of opposition. It's a very important part of the legislative process. If you believe that the bill affects you negatively, or a bill is unfair to you, or a bill is poorly drafted. So again, a little bit about Buffy Wicks. She's been in the office now for about 16 months, right? Since January 2019. She represents portions of Oakland, Berkeley, and Richmond, which is Northern California and very close to San Francisco. She's a member of the Committee on Banking Finance. Now, having watched hours of her videos and interviews and speeches, she ran on a very progressive platform, focusing on women's rights, youth issues, economic security, particularly for minorities. There was absolutely nothing, and when I tell you nothing, that I could not find a single bit, and I'd love for someone to actually stand me corrected here, anything regarding the debt settlement or debt relief industry. In fact, right, if you think about the progressive platform, it intends to help the poor, right? It's supposed to protect the poor, it's supposed to look out for those who are in need and find ways that these individuals, right, are not taken advantage of, right? So let's take a look whether or not this particular legislation, in fact, protects, or does it, the poor. Here's just a list, as I promised you, by the way, of the members of the California Assembly of Banking and Finance Committee. It's primarily Democrat. There are a few Republicans, but again, she's the lone sponsor of this legislation. So if you disagree, you can contact every one of these individuals. Now, so what is Ms. Wicks, Councilwoman Wicks, looking to do? She is looking to amend the prorater law. First of all, I love the word prorater. I have absolutely no idea why the word prorater is a word that is used in California legislation. Typically, when it comes to regulation of debt relief companies and focus on the debt settlement companies, legislators typically use the word intermediary, debt adjusters, debt management services. A prorater is kind of a very strange word, and I hate to sort of emphasize to focus a little too much in this word, but I don't know if I technically agree that the word prorater is the right word to legally define someone who's performing that type of service. Anyway, we could move on. What I've done is what you see on middle of this slide is you see the section 12002.1, which is a definition of prorater. What you see in italicized, right, which is really just a couple of words, soliciting, processing, payment, are the two additions that she's trying to introduce as part of her revised legislature. The highlighted parts, I highlight them specifically for this presentation, right? Um, at the bottom, you see New York, and I've taken it part of what Bianca discussed earlier during this webinar. And I've highlighted, and I've highlighted, if you see, I bolded the word any, and I've highlighted parts so that we can do a little bit of comparison, right? Now, why did I do this? I want you to understand how poorly drafted this legislation is and how little, if anything, it's trying to accomplish. So let's read together. A prorater is a person for compensation engages in whole and part in the business of receiving or soliciting money or evidence thereof, or processing payment for the purpose of distributing the money or evidence thereof among creditors in payment and partial of the obligation of the debtor. Now, first, let's start with the word compensation. I think it's very strange to leave the words compensation, because if you look at the bottom of this slide, typically compensation typically means now or expected in the very near future. Some of the relationships that exist in the debt relief space or debt settlement space, if you really want to granulate this further, is there's expectation of future revenue if there's a profit sharing arrangement in place. So if there's a question whether or not somebody in fact is going to be compensated or receives compensation, just think compensation really by itself is a very strange word to have here. Anyway, engages in whole and part. Now, I love to pick this language. I clearly we can't argue with the word whole. What is part? So if you are operating a website where you don't offer debt settlement services, let's assume that you offer information services in whatever, other financial services. I don't know, selling stocks or trading oil, whatever it could be, or you are not for profit. So do you immediately come into the purview of this proposed legislative change because you're part of the business? Again, it was there from the beginning, but I just think the word part is a very vague and ambiguous word, and I don't like it. I really think it needs to be more what you have in New York, right? Engaging and holding himself out in the business of providing debt settlement service. You can't argue with that. That's pretty clear. So the whole and the part creates a lot of confusion. The word receiving was there. And as I mentioned to you earlier during this webinar, the word receiving is kind of a strange word because according to TSR, you shouldn't be receiving money. You should really be putting into third-party accounts that you have no control over. You can have control because of TSR. And then you have the word soliciting. Now, so first of all, the reason I highlighted the word soliciting money, I just have never seen any legislation ever to have soliciting money. Now, if you take out the word soliciting, and the previous wording was in the business of receiving money, that makes sense. But soliciting money, how could you be in the business in whole and part soliciting money? Even if you say, okay, well, you have to read the other part, for the purpose of distributing money among creditors. So if I would love to see who in fact is considered to be in the business of soliciting money for the purpose of distributing it to creditors. Interesting. I mean, I could also say that an agent, right? An agent of a creditor is in the business of soliciting money for the purpose of distributing among creditors. I realize that I'm granulating this really into nitty details, but I do believe that if you're in the business of proposing legislation and wanting to make a positive change, you've got to at least somehow have a conscious understanding of the words that you're proposing, right? And the last part of this processing payment, again, same comment as we have with the co-sponsored bill we discussed a few minutes ago. What does it mean, processing payment? Wait a second. So if you're processing payment, if you're in the business of processing payment to distribute it to creditors, you now have to be a prorater. So in whole and part. So just for the purposes of this example, I'm sure PayPal might have, well, probably today, in some shape or form. And again, I'm not picking PayPal because of PayPal, but because obviously it's one of the better known payment processors, the money transmitter. to the American public. So does that mean that PayPal now has to become a prorater and be subject to registration? And I think that's quite silly. They're already a money transmitter. They're already licensed on the state level. Doesn't really make a lot of sense. Now we move on to the attorney exemption, right? So we know that for those of us who are familiar with the debt relief space regulatory environment, we know that attorneys are generally, in almost every single state, are excluded from being licensed as a debt settlement or debt relief or credit counseling company. And why? Look, it doesn't matter what kind of lawyer, you don't have to practice bankruptcy law, right? If you're an attorney, whether on corporate level or consumer level, it's not unreasonable for you to assume that from time to time your client's going to ask you to deal with issues involving creditors. And that doesn't mean delinquent debt. Creditors who are trying to collect and you disagree because you believe there's a breach of contract, or you believe someone did not perform the services and therefore you'd like to be able to negotiate down the debt, right? However, I do take an issue when a perfectly normal part of the attorney exemption, as you see crossed out, is being proposed to be deleted. And a very silly, and I'll explain to you why, very silly exemption is being proposed. So on top, we'll just the existing attorney exemption says the services of a person licensed to practice law in the state when the person renders services in the course of his or her practice as an attorney at law. Right? Very clear, very concise. I have absolutely no idea who drafted this for or on behalf of Councilman Wicks, but to include the following proposed revision. Instead of having clear and concise language as it exists now, we have attorneys and law firms that meet all of the following criteria. First of all, it doesn't even say whether it should be in the state of California, right? So basically, anybody from any other state could do this service? If so, I think it actually does the complete opposite. You're not protecting consumers in the state of California. Now, the first prong, and by the way, you have to meet all of the following criteria, and there are three criteria. The first criteria is the services rendered by the attorney or law firm do not result in charges or costs regulated by this division. Rounding up my second decade of practice and teaching law part-time at Hofstra Law School, I have to tell you, I don't know what that means. It's quite unclear. Well, Bianca and I actually spent some time digesting what exactly this first prong, this three-prong test means. I think we know what it means, but it's not very clear because I really don't understand what exactly you have to do to render services as an attorney that don't result in charges or costs regulated by this division. We assume what they're basically what Buffy Wicks sponsored legislation essentially means that if you're performing services that do not fall within the four corners of this legislation, then you're exempt. I think that's what she means. I don't know. I'd like to really hear directly from her. The second prong is fees and disbursements are not charges and costs shared directly and indirectly with a prorater or check seller. Now, I can tell you that fees and disbursements are not charges or costs shared. First of all, as I've said previously in my other webinars, educational forums, I said attorneys in every single state cannot share fees with non-attorneys. I think I understand the purpose behind this language. I don't think it's egregious as the first prong, but that's why you have the 2 stars at the bottom. You have to look at the California Professional Rules of Conduct for Attorneys, which in fact prohibit the sharing of fees with non-attorneys. You can't share fees. You could, use the services of non-attorneys, but attorneys can't generally share fees with non-attorneys for the services that attorneys perform. 3, the third prong, either of the following is true. Again, nitpicking, I really not a fan when people say, one of the following is true. I feel like I'm playing a game show here. I don't know why it was written in such a way, but okay, let's amuse us. A, in the prior year, the attorney or law firm engaged in less than blank, I guess they're going to try to figure this out, number of clients in debt settlement services. B, 50% or less the total number of client engagement of the attorney or law firm involved in debt settlement services. first of all, I am very curious if the California State Bar will have any issues with this language, because frankly, I don't know if really this impedes on their territory, whether or not someone can actually restrict the amount of fees to be charged for the individuals in that state that are not prohibited under the professional responsibility rule of that state. Two, um, if it says, if in prong A, the attorney law firm engage in less than blank number of clients, who is it to say? Why should the state of California mandate who exactly should have number of clients? Let's be very clear. The word debt settlement services, right? Attorney debt settlement services, according to 11 USC 528, and for those who really want to, you could copy and paste and look into it further, but I could tell you in a nutshell, under federal law, bankruptcy services. Now, when I say bankruptcy, it means any bankruptcy law firms or bankruptcy services are considered to be debt relief services. In fact, bankruptcy law firms have to provide a disclaimer or notice to their clients that they are a debt settlement company, right? The services that they are performing in the furtherance of providing bankruptcy services are debt relief services. I'm sorry if I used the word debt relief services. So I don't understand why exactly the state of California, particularly the Council on BICS, would like to restrict the compensation that attorneys and law firms make while providing debt settlement services, which debt settlement are considered to be debt relief services. Anyway, I think that is quite fascinating. Now, fee caps. Well, the proposed is she struck in her sponsored legislation the fees that were already significantly lower than in most other states, and in fact wants to have 5% of savings from a completed settlement calculated as the difference between the amount of debt enrolled and the settlement amount. Now, I want to step outside of my legal shoes and ask a very interesting question. So let's assume a person has $25,000 of unsecured debt, and the debt settlement company provided over the course of, well, let's say 36 months, 3 years, right? That's usually kind of an average debt settlement program, is about 3 years, provided a service to negotiate with multiple creditors and reduce that debt by $10,000. $10,000. In this case, the 5% from $10,000 of savings means $500. $500 is not a lot of money to make for negotiating with probably multiple creditors and spend 3 years servicing a file. Even if you look at the fee caps that credit counseling companies have following the 2005 legislative revision, federal legislative revisions, even they make more than that. So even if you provide $15,000 off, if you shave that off of $25,000 debt, you're looking at $750 fee, which doesn't seem like a lot of money or commercially feasible for anyone to be in this type of business. Now, if you thought that part was bad, let's talk about another part. So, as you can see, she, nixed most of the fee caps that currently exist. By the way, when you're trying to lower fees, for any type of service because you feel the existing fees that exist are too egregious, there has to be some kind of level. For instance, justification of why you're proposing this, right? So there has to be something that says, we believe that most consumers were hurt or didn't get the fair buck of services that they paid for the services that they received. So I have absolutely no idea how these numbers came about, why the 5% in savings, where it came about. There was no discussion. There's nothing discussed on her very active social media profile. There was not an interview given. And you have to raise some eyebrows. So where exactly, who's feeding Councilwoman Bix with this information, right? I mean, regulation is important. But proposing fees that seem very insensible. It almost like, let's use as an example. If an average oil change costs, I don't know, $20, right? And from that $20, the auto shop will make $5, right? Because between the labor cost and the fuel and the oil cost them $15, they'll make $5. But now imagine the state of California thinks, well, you guys are overcharging an oil um, car oil changes, and you can't charge more than $5. How many oil change, how is it going to benefit consumers? This is a very similar example. These limitations on fees need to be in perspective of what the customer complaints are, what the regulatory regime is across the entire country, and they also have to be reasonable. Otherwise, it doesn't seem, they're very arbitrary and almost capricious in nature. So here's another restriction. The total monthly payment by a debtor into a debt settlement trust account shall not exceed 10% of debtor's monthly net income, right? And then part two is, what that monthly net income is. I have a real problem with this as an attorney. I have a real problem with this. This is a problematic. At what point do you consider the 10% net income? At the point that you enroll into the program? Okay. Let's assume you could, first of all, I think at this point that you have people working for debt settlement companies trying to figure out what exactly is 10% of that is monthly net income. Okay. And I'm not an economist. I am not a consumer debt economist, but 10% of debt income. So if somebody has significant amount of debt and wants to get out of debt, spend more than 10% of net income doesn't seem also quite reasonable. But again, what do I know in that space, right? But at what point legally do you have to calculate that monthly net income? If you have to, so for instance, let's assume somebody, John Smith, fictitious name, we rolled into the program 12 months ago. And in March 2020, as a result of COVID-19, John lost his job, but John wants to continue making payments into his debt settlement program because XYZ debt settlement company was able to resolve it for significantly less money than he would have had to file for bankruptcy, or maybe he doesn't want to file for bankruptcy. For those of you who are, have filled out or helped somebody fill out the PPP application, every single lender, including, by the way, the SBA, will ask you for principal, or if you, principal, the owner of the company, any owner of 20% or more of the company had filed for bankruptcy in the past 7 years, right? So if John doesn't want to file for bankruptcy, but now John's net income, according to B2, has, his payments have increased to 10%. You're essentially saying that according to this proposed legislation, the debt settlement company would be in violation, right? And what are we doing? We're also potentially opening up floodgates of litigation because, now you basically someone could easily be in violation of B1. Anyway, let's move on. Disclosures. Disclosures are very, very important. Consumers need to understand the pros and cons of any program. By the way, regardless of what program, whether credit counseling, whether consumer bankruptcy, or debt settlement, or any other program out there, it's important to educate consumers. But these disclosures have to be reasonable. They have to make sense, right? They have to make sense. And they also have to be written in such a way that somebody understands this. So I'll give you an example. This is the disclosure that's proposed by Buffy Wake's legislation. It says, number 2, the number of months estimated to settle all debts. The true disclosure should be is estimated for you to participate in the program, because somebody could pull out a particular debt out of the program. Somebody may not want to include all debts in their program. So that's really not the proper disclosure. I think the proper wording should be here, program. Another thing that I think is strange is number 4, the debtor is, you have to disclose that the debtor is required to pay all bills unless the creditor states otherwise. Well, geez, aren't you really helping out creditors by including that disclosure? If you want to help consumers, if you'd like to warn them about the risks of a debt settlement program, well, telling them that they have to continue making payment defeats the entire purpose of them being in a debt settlement program, because there's no leverage to negotiate with creditors. And if you're a creditor listening to this webinar, you're probably saying, well, I don't like when debt settlement companies send me cease and desist letters or tell their clients not to pay. The bottom line is there is no debt settlement if you're continuing to pay all bills. Let's use it as a very practical example. John Smith comes to a consumer bankruptcy lawyer. Doesn't matter where that lawyer is located, anywhere in the 50 states. And John Smith says the following: I'd like to file for bankruptcy. And the lawyer says, okay, I'm going to need the following documents from you. And hopefully in about, I don't know, 2 weeks to 30 days, I'll be able to prepare a petition and we'll file it with a court. John Smith asked the lawyer, well, do I have to continue paying bills that will be discharged? Can you imagine the amount of malpractice that a lawyer would commit by basically telling a consumer that, go ahead, make that payment because, you have to make that payment? No, you don't. If you believe as a counselor, as a consumer bankruptcy counselor, that, you have a client with dischargeable debt, why would you tell him to continue making payments if obviously you're trying to help that client? Same thing goes here. Okay. So that's basically the disclosures part. I just wanted to point out a couple of interesting. Anyway, that is the end. We're close to the end. This is a list of services our law firm performs for the debt relief industry. We work with lenders, debt settlement companies, credit counseling companies. We work both in federal and state level, licensing, regulatory investigations, and really be delighted to assist and discuss any issues that you have concerning these proposed and enacted legislations. You could always subscribe. We have a free information website. You could keep up with your legal, regulatory news, or you could keep up with your market news affecting the debt relief industry. Debt-relief-watch.com. It's free. You get actually direct feeds from the CFPB and the FTC, so you can keep it all. You get all the information in one place. And of course, always a big thank you to Jay Mangiano from Limit Break Digital Marketing Design. Jay has been instrumental in helping us put together our previous programs, including this program. His information is here. He performs a significant amount of marketing and design services in the fintech space, in the debt relief space. So please reach out to him. I always like to give him kudos. And finally, I'd like to thank my co-host Bianca for helping me organize and put this together. She's done an outstanding job, and we thank you for joining us today. And we hope this was informative. I hope there was a little humor and cynicism, and we hope to see you at our future webinars. Thank you for joining, and have a wonderful day.